My Lord, my Lady, I propose to take the issues in the order in which they're set out in the Statement of Facts and Issues of paragraph 16, which corresponds with the order that my learned friend has taken them. So I'll first deal with the argument that there were material misdirections as to specific intention for murder and armed robbery. Second, what is said about the judge's failure to leave lesser alternative verdicts of robbery and manslaughter. Third, what is said about the failure to adequately differentiate by the judge between the different cases and evidence. And then finally, and if so, if indeed necessary, deal with the proviso. So the first issue, the directions on intention and joint enterprise, I propose to just split my submissions up into three parts. So I'll first look at the arguments regarding intention that were dealt with and rejected by the Court of Appeal. And I'll do that briefly because my Lord, my Lady has already been taken to the Court of Appeal's judgment and will have read it in their pre-reading. I'll secondly look at the evidence against the appellant, which consists of the statement to Superintendent Clark and the statement to Corporal Seymour. And then thirdly, I'll deal with the specific points raised by the appellant, in particular focusing on the foresight issue, if I can call it that. As we note in our written case at paragraph 6 at 2431, the submissions that are advanced before the board on intention and joint enterprise essentially rerun the arguments that were, we say, rightly rejected by the Court of Appeal, namely that the judge misdirected the jury as to the specific intention for the Crown to prove in order to support a conviction for murder and armed robbery on a joint enterprise basis. As such, a preliminary point arises, did the Court of Appeal err in law or principle in dismissing those arguments? And we say, unsurprisingly perhaps, that the Court of Appeal was right to reject those arguments for the reasons that they set out in paragraphs 62 to 73 of their judgment. In the Court of Appeal, the appellant advanced two main arguments. The first was that the judge's directions were inadequate given the evolution of the concept of joint enterprise following Jogee. Essentially, it was said on behalf of both the appellant and Mr. Williams in his appeal that the judge fell into error by equating foresight with intention. And then second, it was said that the appellant's conviction was not supported by the evidence. As to that first point, the Court of Appeal held the judge correctly directed the jury, and as I said, the board will have already read the Court of Appeal's judgment, but if I may just give you some references. Paragraph 64 of the Court of Appeal judgment, which is 2322, electronic bundle 2322. The Court of Appeal set out the judge's direction there to consider each defendant separately, and I'll return to that point when addressing what I'm calling issue 3. Paragraph 65, which is the top of page 2323. Court of Appeal refer there to the misstep that had been taken and was corrected by the board in Jogee, namely treating foresight as an inevitable yardstick.
I think it's common ground, isn't it, that Bahamas didn't take the wrong turning?
Yes, my Lord, and that's a short circuit to the consideration that we see at 71, top of page 73, 2326, where the Court of Appeal quotes the judge's direction on joint enterprise, then identifies the key issue for the jury, and I'll just perhaps emphasise that. The jury had to consider whether Williams, Bastian and Johnson shared a common intention to rob the two women and to kill, if necessary, to facilitate the robbery as part of the joint enterprise. So that, I say, is right insofar as that is...
Where did the judge say that?
My Lady, I'll come on to the judge's specific directions because we have to look at the summing up, obviously, as a whole. I would accept, though, that it is not said in those succinct, precise terms as we see at paragraph 71. Johnson is then referred to, and going back to my Lord James's point, perhaps worth just having a quick look at Johnson. It's tab 6, starting 2607. And if I can pick it up at paragraph 96, please, which is 2641. This is the then President of the Court of Appeal of the Bahamas.
Sorry, could you just give me that?
Of course, my Lord. It's 2641 is the page of Johnson I'm referring to, and it's bottom paragraph 96. And this is the then President saying, the requirement of intent in cases of common design and extended common purpose, to which their Lordship returned in Jogi and Ruddock, and which was the position in England prior to Chan Wing Sue, has always been the position in the Bahamas, at least since Farquhar. Then over the page, and this is obviously dealing with the facts of this specific case, but I say it's illustrative and instructive in our present case. Suffice it to say that in the present case, there was direct evidence from the actual shooter that he shot the victim. There was direct evidence from the appellant which, if believed, conclusively proves his agreement with the shooter and the others to rob the victim. Moreover, as noted, the appellant admitted foreknowledge of the presence of the weapons and his participation with others by his presence in waiting with them in the bush awaiting the deceased's arrival. His barging into the deceased's house with his armed associates and his presence in the house during the incident is evidence from which the intent to assist in carrying out the plan to rob and to kill, if necessary, may be reasonably inferred. And then there's a discussion of section 12.3, reference to Farquharson. And then if I can return...
I mean, you rely on that. Why? I mean, that makes it clear you've got to explain to the jury that you can infer that intent, but you've still got to find the intent.
Although, yes. And when I come to the directions, and I look at the directions in respect of intention, then I do say that is where the judge gets to, although I acknowledge there are difficulties in some of the directions, and we acknowledge that in our written case. Then, if I may, just return to the Court of Appeal's judgment, which is the end of them dealing with this first point about specific intent. So back to page 2326, which is the Court of Appeal's judgment, and it's paragraph 73. In this case, Williams and Bastian admitted that they were part of a joint enterprise with Johnson to snatch purses from the white women, with knowledge that Johnson was armed with a firearm. These matters were properly before the jury, and the learned trial judge cannot be faulted for the directions given. These grounds have no merit and must fail. And obviously, I will address, there's 2 points really that arise there. First of all, a point is taken by the appellant of whether or not there was really an admission on the part of the appellant that they, as it says here, admitted they were part of a joint enterprise. I think a point is taken, it may be a minor point, and Miller and Friend didn't develop in all the submissions, but what I think is said at paragraph 38 of the appellant's written case is that the Court of Appeal there erred in point of fact, and what is said is, by the appellant, if it's suggested, as appears, that the appellant effectively admitted he had entered into joint enterprise, that was in fact a contested issue of fact for the jury. Obviously, we say that's not what the Court of Appeal is saying. The Court of Appeal is saying, effectively, there at paragraph 73, is that the jury must have found that the appellant was part of a joint plan and knew Johnson was armed, based on what he said to Superintendent Clark. Clearly, if the jury had not found that, they wouldn't have convicted him of armed robbery and murder.
It's an odd way to talk about what the jury must have found by saying these were admissions as to knowledge as well.
Well, my lady, I think this goes really to the heart of perhaps the appeal, that I think the trial judge and the Court of Appeal, when reading the statement to Superintendent Clark, effectively formed the view that that could only be read in one way. And I say that is entirely reasonable for them to form that view, and that's the way in which effectively the judge summed the issue up to the jury. And that perhaps leads on to the second part of my submissions on this first issue, which is the evidence against the appellant. Obviously focusing, as I must, on the statement that he gave to Superintendent Clark. I don't discount Corporal Seymour, which adds to it, and where he admits to stealing the purses and then throwing the purses and then leading a police officer to where the purses were found. But it is really Superintendent Clark's statement that one needs to focus on. As Miller and Friend has rightly identified, the relevant passage of the evidence of Superintendent Clark is misquoted in the SFI, for which I think both parties apologise. It is, though, accurately quoted by the judge in summing up, although I do accept that the judge does refer to a gun in passages of the summing up, but when quoting Superintendent Clark's evidence, the judge gets it right, if I can put it that way, and that's at 1669, line 6. There are other references throughout the summing up to the gun as well, and if I can perhaps just give the board those references. It's 1687, line 11, 1690, line 22, and 1692, line 32. But obviously, the critical one is when the judges... Sorry, the last one was 1692, line 32.
32, thanks.
But I submit that the critical one is the judge saying this was the evidence of Superintendent Clark, and when she gives that evidence to the jury in her summing up, she accurately records that he said the gun. The statement of Superintendent, or the evidence rather, in the transcript of Superintendent Clark is at 640, lines 12 to 16. And the Crown's case is that there are effectively 3 points to note about that statement.
Sorry, can you just give me the reference again?
Yes, so Superintendent Clark is 640, lines 12 to 16.
Thank you.
The first point to note is that the appellant says, I was at double D's. So the appellant places himself at the scene. He's not saying I was elsewhere, he's saying I was at the locus where the incident took place. The second point is that the appellant places himself at the scene, in his words, when the vibe went down. Again, the is important in my submission. The use of the definite article, the, indicating that the appellant is referring about something that he knew about already in my submission.
But the vibe that was put to him was bag snatching, wasn't it?
My lady, it was, and...
So the vibe was snatching bags, not shooting.
My lady, the vibe was snatching bags, yes. That was what was put to him in cross-examination.
Yeah.
And I say the reasonable inference the jury would have drawn, and obviously did draw, was that the appellant was saying, if we just pause there before we talk about the gun, that he was present when the vibe went down, meaning he was present when, effectively, the plan to snatch purses was carried out. And as Lady Simler points out, he was cross-examined as to what was meant by vibe. That's at 1461, line 21. He denied using the word. The Crown then returned to the point later in cross-examination. It's 1466, line 27 to 1467, line 20. And it was put to him that the vibe he was talking about was the snatching of purses. So it's 1466.
This is...
Oh, is that a
This is not evidence.
sorry, is that a bad reference? Yes. Sorry, let me just find the... Sorry, yes, the reference I was thinking of, and this goes, perhaps corrects an answer I gave to Lady Simler a moment ago. It's 1467, line 17. He's asked, the vibe was you snatch a white woman bag by double D's, and that is when Craig shoot at the white man. That is the vibe.
1467, line 40, sorry.
Yes, my 1467, line 17.
Thank you.
The vibe was snatch a white woman bag, and that is when Craig shoot the white man. That is the vibe. So what is being put to him, although it could have been, like I said, could have been put to him clearer, is it's not simply snatching of bags, but it is the shooting as well. And he says, sir, no, sir, never took place. And Superintendent Clark is not cross-examined by the defence as to what the vibe might refer to. So that's the second point. So you've got the first point, placing himself at the scene, I was at double D's. Secondly, when the vibe went down, snatching bags and extending to the shooting. And then the third point...
So, I mean, that's just being put to him there.
It is.
It doesn't mean that that's what it means, does it?
My point, by the way, is that this is what the reasonable inference of the jury, and that was the Crown's case, and we.
Okay.
So which one was the Crown's case? That the vibe was snatching bags, or the vibe was snatching bags and a shooting?
It would have to be the latter, my lady, because the Crown's case was that. In this case, the requisite intention, as far as the appellant is concerned, was to be inferred from the fact that he set out with Johnson to steal purses. He knew Johnson had a gun, and owing to the propensity of the use of a gun to cause death, intended lethal force would be used if necessary in the furtherance of that planned robbery. That's how the case was put to the jury.
By prosecution or by the...
Well, my lord, as I say, it's not as clearly put in the directions, and I'll come on to the judge's directions, but that is...
We don't know how it was put by the council, do we? Don't have a record of that.
No. No, I mean, what we do have is in the...
No case submissions.
In the no case submissions, and I'll give you a reference because it is quite a useful summary of how the. So it's 12, I think it's 1229. Mr. Armbruster. Now, with respect to Anton Bastian, we know, and then he sets out. We know that the vibe that he's talking about when he made the oral confession was when he snatched the woman's bag, and at the time another person whom he must have been with, otherwise he would not have known that person had a firearm and actually used it. And then that section where he sets out, effectively the Crown's case ends at line 29.
And that's page, again?
That's 1229, my lord.
1229 line, right. Okay.
And then the third point from the statement made to Superintendent Johnson is the reference to the gun. And again, the use of the definite article rather than the indefinite article in my submission is important. The inference to be drawn is that the appellant is referring to a specific gun which he must have known about in advance. And the significance of the definite article doesn't appear to have been lost on the Court of Appeal. We can see from the transcript in the Court of Appeal submissions, the President picking up on a point that the reference was to the gun as opposed to a gun. And we see that at 2188, lines 5 to 10, which is the transcript of the Court of Appeal hearing.
Did it emerge in their judgment?
Well, no, and my learned friend is right that in the Court of Appeal's judgment they misquoted as a gun rather than the gun.
So it lost its significance?
May well have done, my lady. Now, it has been suggested that...
I see Justice of Appeal Jones goes on to say he didn't say he knew about, he had the gun.
There's a lot of... I mean,
a lot of discussion.
There is a lot of discussion in the Court of Appeal about several issues that don't find their way into the judgment, if I can put it that way. and the way it was argued in the Court of Appeal, well, I think a lot of dead ends were run into. Now, it is suggested by the appellant that little, if any, reliance should be placed on the oral statement because it wasn't verified by the appellant. And just briefly, two points on that. The first is a point that I think the board already has, which is the appellant did not seek to exclude the statement that he made to Superintendent Clark, which is in contrast, obviously, to the statement to Corporal Seymour, which he did seek to exclude, and his record of interview and caution statement, which were excluded under sections 20 and 178 of the Evidence Act. And just, again, to give you some references as to what the appellant's position was on Superintendent Clark's statement, at 56 lines 11 to 19, there's a discussion.
At page?
Sorry, 56 lines 11 to 19. There is a discussion with the judge as to what objections were being taken. So this is prior to the voir dire, to the Crown's evidence, and Mr. Reckley, on behalf of the appellant, confirms that there's no impropriety being alleged as regards the initial statement, namely the statement to Superintendent Clark upon arrest, and he says it's an issue of fact upon which the appellant will cross-examine Superintendent Clark. And then in the voir dire, page 493, lines 18 to 19, Mr. Reckley confirms again, just for the record, he says, I'm not objecting at this point to any statements made to Clark upon arrest.
What was the cross-examination? Is there a good reference for that?
The cross-examination of Superintendent Clark, it's 643. And this is my sort of second point, if you like, on reliance. Because at 643, and this is why I stood at the beginning of my learned friend's submissions earlier. He starts his cross-examination by saying, "Good afternoon, Mr. Clark." And he says, "Now, Mr. Clark, just to be clear, the story that you just told us, did you have a chance to make contemporaneous notes of what you said?" And the answer is, "Yes, sir, I did." "And where are those notes?" "In my notebook." "I guess you don't have that with you now." "I have it with me." "You have it with you now?" "Yes." And that's the end, perhaps unsurprisingly, of that line of cross-examination.
That is page 643.
That's 643, lines 10 to 19. And there's more, just a bit further down that page at 643, line 28. Superintendent Clark confirms that a female officer, Sergeant Stewart, was present as well. And then it's suggested to him at the bottom of that page, "I'm going to suggest to you, sir, that what you've just said was not what was actually told to you by Mr. Bastian at all." And then over the page, "Do you agree with that?" "I disagree with that. I said exactly what he said to me." And it's right to say that Officer Stewart was not called because I think the way it was put is she wasn't within the precinct of the court, but no objection was made to Officer Stewart not being called. And it's a fairly short cross-examination. It concludes on page 645.
Can you just help me about flowers and double Ds? Are they the same place or are they different? And where did the shooting take place, at double Ds or at flowers?
Well, it's
because
unhelpfully, my lady, I was going to say it's slightly unclear on the evidence because what the jury had the benefit of, and obviously we don't, is security camera footage, so CCTV footage, and there was evidence that the people that snatched the bags ran round the corner of double Ds, although it's put slightly differently at different places in the evidence. But there's, as I understand it, and the SFI was put on the basis that there's no issue that the shooting took place, I think the SFI says, in the area of double Ds.
Yes, but in the submissions to the jury, as I read them, or some of the points that were being made, there was a distinction being drawn between flowers and double Ds, and the shooting was at flowers. and the admission of being present at double D's wasn't an admission of having seen the shooting. Is that, can you help about that, or is that irrelevant? It may be that it...
Well, my lady, I think the basis on which we're proceeding, sort of factually, if I can put it this way, is that the shooting was in the vicinity, effectively, in the area of double D's, and therefore it is irrelevant if there's a reference in the evidence to flowers.
All right.
I don't think it is being said by the appellant, although I'll be correct if I'm wrong, that there is some distinction to be drawn between flowers and double D's.
Thank you.
Well, the Superintendent Clerk says it's right round the corner, page 645.
Yes.
Can I help in this way? That I'm instructed that there is a corner and it's around 100, 200 yards distance, and the point was taken by Defence Counsel in the no-case submissions that this was a different area, therefore the admission is not to this being the same incident, etc. I think for the purposes of the board's hearing, essentially it's a location in the vicinity of, but whether or not it's consistent or inconsistent with being a person involved in what happened in the street in some location, there was some debate for the jury to consider about where it was placed. Or certainly there was debate about that before the judge on the no-case submission.
And the final point, just on this cross-examination, as I say, it's a fairly short cross-examination, but the counterfactual is not put to Superintendent Clerk, so it is not, he's not questioned about the meaning of the gun or the vibe. Now, as well as Superintendent Clerk's statement, the Crown relied on Corporal Seymour's statement. That is in the transcript at 742, lines 22 to 25. So that is the statement where the appellant confesses to taking the white woman's bag and then identifying where he had thrown that bag after he fled the scene. And then, as the board will know, the Crown's case was that the appellant then took 2 officers to where that bag had been thrown, and that's where the bag was retrieved. And in light of those 2 statements, in my submission, the Court of Appeal was plainly right to hold that the jury was entitled to draw the reasonable inference from what was said by the appellant, that he was part of a joint enterprise with Johnson to snatch purses with the knowledge Johnson had a gun, and the inference being that because Johnson has a gun, lethal force would be used if necessary in the furtherance of the plan to steal purses.
And that's what's not put to the jury. We need that further step.
I think I would accept, and this goes to Maloney Friend's, I think, second point about the development of the common intentional scope of the agreement. We accept in our written case that the summing up was not perfect in those respects, but the judge did give clearer directions concerning the nature of the common intent shared between the appellant and his co-defendants. Those directions, I say, were adequate. The jury would have understood from the directions, the Crown's case, that there was a common plan to steal purses, to do so armed with a gun, and then it was for them to determine the extent of the common intent based on all the evidence. And
But what did the common intent need to be? Where was the jury explained what that intent needed to be?
Well, my Lord, if I may, and I'm not, as it were, dodging that question, what I propose to do is just finish this second section dealing with the first issue, which is the evidence against the appellant, and then deal with the appellant's specific complaints, which is really addressing head-on Your Lordship's question to me and looking at the directions at that stage. Those 2 statements was the only evidence against the appellant. I do, though, mention the evidence against the other defendants, because the Crown relied on both oral statements and written records of interviews outlining their involvement in the joint plan to steal purses whilst armed with a gun. And the board has those cases against the other defendants. They're set out for convenience in paragraph 6 of the SFI. It's 2374. So as regards Johnson, in statements to the police, he admitted being the shooter, but obviously stated that the deceased approached him and was shot during a struggle. That gave rise to provocation being left to the jury. Williams admitted to snatching a bag, but not shooting anyone. Dorfeville stated he was the driver, but did not know the presence of the gun. Now, of course, I accept those out-of-court statements of the appellant's co-accused is not evidence against the appellant, and that's a point, when we look at issue 3, that the judge repeatedly made to the jury quite rightly. The reason I mention that evidence against the appellant's co-accused is because, in line with the judge's directions, the jury would have considered each defendant in turn, no doubt starting with the principal shooter, Johnson. And having accepted Johnson's confession and having found him to have been the shooter, the jury would then have properly asked themselves whether that evidence and that finding that they have made was consistent with the appellant's statements to the police. That doesn't do any evil, as it were, to out-of-court statements of co-accused being used as evidence. What I'm just saying is this is how the jury would have looked at the case based on the judge's directions. So this isn't, as it were, additional evidence. This is the jury, perhaps, if I can put it like this, sense-checking their own conclusions as they work through the evidence. And considering each defendant separately in turn, it is unsurprising on the evidence that the jury found that a joint enterprise was established, as each defendant had mapped out his role in the offences to which they were charged. And in my submission, the jury was plainly entitled, in line with the directions, to conclude that it was the appellant Williams and Johnson that were part of the joint enterprise with respect to the murder and the armed robbery, and they acquitted Dorfeville of murder and armed robbery because they accepted his evidence that he did not have knowledge of the gun.
But you accept that the only evidence on which they could have come to their conclusion in relation to the appellant was the two statements?
I do. Turning then to the 4 specific complaints that are made as to the judge's directions. I think the board has my overarching submission. We've set it out of paragraphs 37 to 39 of our case, which starts at 2444. So as regards Johnson, we say the intent to kill was to be inferred from the firing of a gun at close range during a struggle, and there being no reason to doubt the presence of intent to kill from the evidence. And as regards the appellant, we say the requisite intention was to be inferred from the fact that he set out with Johnson to steal purses, he knew Johnson had a gun, and owing to the propensity of the gun to cause death, intended that lethal force would be used if necessary in the furtherance of that planned robbery.
It does all depend on knowledge of the gun at the outset, doesn't it?
And that's why, my lady, I say the statement that's given to Superintendent Clark is critical.
Yes.
Because that is the only evidence.
But you said a reasonable view of it is that it admitted knowledge. But do you accept that another reading of it was he knew about the shooting at the point at which he's giving the statement, and that's what he's referring to? It doesn't expressly or on one view, even implicitly, accept knowledge at the outset.
I mean, the difficulty, my lady, is, I mean, this isn't a case where I think it could be said that the jury's findings are so unreasonable in the Wednesbury sense that the Court of Appeal or indeed the board could substitute its own findings. So I don't think I need go as far as to say that an alternative reading is an impossibility. Just that
it's just the jury had to be sure about
of course
those matters.
Of course. But the jury would have known. I mean, this is, in a way, it makes it a more straightforward case to the jury that they know that the only evidence which they are considering against the appellant are these two statements, and critically, the statement of Superintendent Clark. So that is their sole focus is on that statement and what they reasonably infer from what the appellant said himself to the police officer. The first point, the realisation foresight point, so namely, as he said, misdirected the jury on a joint enterprise basis that if he realised or foresaw or had knowledge that Johnson might act with intent to kill. Now, the board has been taken through the summing up in detail. What I propose to do is just give some references to where the judge deals specifically with intention. The first, at 1678, law requires the prosecution to prove so that you feel sure that the following ingredients, namely one, Carl Brunner is dead. Line 6 to 13 is the paragraph I'm looking at. 2, the person or persons who inflicted the harm intended to kill Carl Brunner. So that's the first reference to intention. The judge then deals with the joint plan, so it starts here on this page, 1678. If one goes to 1679, 24, the next ingredient of murder that the prosecution must prove to your satisfaction so that you feel sure is that the person who shot Carl Brunner intended to kill him. And then says intention is not capable of meaning that you cannot go into a man's heart or open his brain to determine what he intends. You infer intention from looking at all the surrounding circumstances. Then next page, 1680, starting at line 2, the law acknowledges the difficulty with the word intention, and then the judge quotes. He says, and I quote, so section 12.3, and then at 13 says, simply put, a person is presumed to intend natural and probable consequences of his actions. And then further,
that context there is the person who's shot.
Well, it's dealing with, that's why I took you to 1678, where the judge introduces this section as the prosecution alleged they were all part of a joint plan to rob, which resulted in the death of Mr. Brunner. So he's here dealing with, not specifically the principle, he's dealing just with the concept of joint enterprise murder in my submission. And perhaps that's made clearer at bottom of 1680, lines 27 to 30, where he says, at the end of the day, you cannot convict the perpetrator or perpetrators of murder unless you're sure that he or they had the specific intention to kill Carl Brunner.
But this is all in the context of the shooter.
Yeah.
My Lord, yes.
Yeah. I don't think the jury would understand it to be going further than that, do you?
Well, my Lord, it's introduced by as I've said already, the joint plan, and is dealing with perpetrator or perpetrators. So he's not dealing here solely with the intention of the shooter, Johnson. So at 27 to 30, you have a clear direction in my submission that you can't convict any of the defendants of murder unless you're sure that he or they had the specific intention to kill. And then again at 1682, 9 to 11, the judge here is dealing at line 4. So the question for you to determine, that's if you find that Craig Johnson was the shooter.
Which rather supports my Lord's point. And if you go back to 1681, the judge is clearly talking about the person who shot Kyle. She talks about the medical evidence, the nature of the gunshot wound to the neck, and then she goes on 1682 to talk about the others. Isn't that right?
Well, my lady,
I don't think she's even going on to talk about the others at that point. I think she's still
Yeah,
talking about
she is, yes.
Johnson.
well, my lords, my lady, you hear what I say about 1680, lines 27 to 30, and it's difficult to square those words of perpetrator or perpetrators if you're not talking about all the defendants. So I say that that is a clear direction, that you can't convict any of the defendants unless they have a specific intention. But I do accept that when we get to 1691...
91 or 81?
91, my lady.
So there's nothing else directly relevant to secondary parties in this passage?
In that passage?
It's only that one line that you rely on, perpetrators?
Yes.
Right.
And we get into specific directions about joint enterprise, and the reason I take you to 1691 is that's where, at line 27, you have the example, if one of the gang A and not Ian has a knife, and in the course of a fight uses it to kill, A will be guilty of murder. The prosecution proves that he intended to kill, but in addition, each of the other gang members, B, C, or D, who took part, may also be guilty of murder, but only if, when he took part, he knew of two things. A, had the knife, and 2, he shared A's common intention to kill or realised or foresaw that A might use the knife to kill. And then that formulation is repeated 1692 further down, and you're taken to this by the appellant, lines 16 to 28, realised or foresaw. Now,
So what do you say about those two passages?
in my submission, the judge is not saying anything less than an intention to kill is sufficient. The judge is saying that in determining the appellant's intention, one can ask whether he realised or foresaw the use of lethal force. I suppose I would put it this way, the judge is essentially directing the jury to consider the scope of the joint enterprise.
Except he's talked about intention to kill, and then he says or realised or foresaw.
Again, I accept that this could have been clearer.
So just can you help me? What should the jury have understood by either find an intention to kill or realised or foresaw that A might use the knife? What should they have understood from that?
That nothing less than an intention to kill is sufficient.
And you went on.
And that in determining the appellant's intention, they can ask whether he realised or foresaw the use of lethal force.
Well, you'd accept that that's a very muddled way of telling a jury that it's just intention they have to be satisfied by, but that in deciding on intention, they can use evidence about realisation or foreseeability.
Oh, I missed the first. Did you say muddled was the word
Yes.
used? I would accept it could be clearer, is I think how I put it in our written case. I mean, the appellant says in their case and earlier this morning that the applicability of section 12.3 may arise where foresight of consequence is properly an issue, but they say it logically cannot convert an act that one accused does not intend a co-accused to commit, so i.e. one that is not within an agreed common purpose, into one that the accused did intend, I think is what is said. And I say, well, that may be so, but it is really of no consequence in the present case, because the Crown's case was that the appellant knew Johnson had a gun and intended he would use it and thus use lethal force to effect the robbery, which was undoubtedly the common plan and intention. Which is the point I make in issue 4 in respect of the proviso, that if the board was to conclude that there has been a material misdirection on intention, then that really is the submission I make on the proviso, that is any jury properly directed, given the evidence and given the Crown's case, would have convicted of joint enterprise murder and armed robbery on the facts, based on going back to Superintendent Clark's statement.
But in the light of the direction which the judge actually gave more than once, the jury might have concluded that it was enough that the appellant knew that he had a gun and might use it.
I then come back really to the passage at 1680, which the jury would have had in mind, that an intention to kill, you must have an intention to kill in order to convict of murder.
Thank you.
Can I just ask you this? In the summing up, starting at 1686, at line 2, the judge goes to armed robbery, and I think, is this right, that goes on until page 1691, and at line 6 she then moves to murder. Is that the right way of reading the summing up?
Yes, 1691, yes. Well,
So the previous 4 or 5 pages is concerned with armed robbery. Now, for armed robbery, would it be sufficient that the appellant knew in advance that Johnson had a gun?
yes,
That's all that would be needed.
yes.
No, wouldn't need to there be any common intention that the gun be used.
No, that Johnson had a gun and
Possession of the gun would be sufficient.
and he was then going with the appellant to snatch purses. Yes.
Yeah. So a common plan to snatch purses and knowledge that Johnson was in possession of a firearm, even if there was no intent or on the part of Johnson to use it. Never mind, there's still armed robbery there.
No, and I think that's common ground.
Okay.
I'm not sure it is. I think the way it was put by the appellants is that you have to know the gun's going to be used in the robbery. Not in a particular way, but actually used in the robbery, as opposed to being in his pocket.
I even go slightly further on our case that we say no. That's like intend, not just no.
Sorry, I didn't hear that.
Intent, yeah.
Sorry to jump over. Just to be clear about the appellant's case on that, we say that for the armed robbery, you have to intend that a gun be used as part of the robbery, even if conditional intention,
I see.
but knowledge alone wouldn't be enough. That's the proposition we make.
Well, my lord, I mean, the Crown's position is that possession of a firearm and going equipped with that firearm is sufficient to ground a conviction of joint enterprise armed robbery.
See, armed robbery, as I understand it, is defined in section 3392 of the Penal Code,
Yes.
which we see in the appellant's written case at page 2388, paragraph 8. So, whoever commits robbery, being armed with any offensive instrument, or having made any preparation for using force or causing harm, shall be liable. And then there's a proviso, which is commits robbery being armed with any offensive instrument. So, on the face of it, that looks as if it's just possession of the instrument or firearm, which is sufficient to make the robbery an armed robbery. But is that true also of, so that would, on the face of it, apply to Johnson, but is that true also of others involved in the joint enterprise? So that was, in a sense, the point of my question. Is it enough that the appellant knows that Johnson is armed?
Well, we say yes, in just applying some normal principles of joint enterprise or extended joint purpose. Yes.
Yes, okay, thank you.
I suppose it depends on what's meant by armed. I mean, means you have the gun for the purpose of the robbery, as opposed to simply having it in your pocket.
I think if I needed to sort of give an answer to that, I think I would accept that. It has to be going. The gun is being conveyed to the scene as part of the
So going equipped.
As part of the plan. Yes, effectively going equipped.
Yes, that's what armed means.
Yes.
I see.
As part of this, as I understand it, as part of this same, if I can call it the foresight complaint, the appellant criticises the judge for not directing the jury that the joint enterprise must be in continued existence. Now, we say there's nothing in that criticism. The judge did direct the jury that intention may arise on the spur of the moment. That's, we see at 1690. That's line 10, well, lines 9 to 11, 1690. And we say that if a jury found that intention existed when setting out to rob, they would have no difficulty in finding that the intention continued when the defendants encountered difficulty in carrying out the robbery, it being a continuing act, including when the victim was killed. And although, again, not explicit, given the directions that were given that the jury could only convict if they were sure the appellant knew that Johnson had a gun, and that is perhaps an important direction, that's 1691, line 27. That direction, we say, need not be read at the expense of implying an intention that the gun would be used to kill.
Well, sorry,
1691,
1691 line
27.
27 is the Ian and Gown example.
Let me give you. Let me check that reference.
Yeah, we'll come back to him.
Oh, sorry. Did I 16?
That's passage A that we were taken to this morning, that you referred to a moment ago.
Oh, is it?
Oh, sorry. It's 16. It's 1692, 16 to 27. So it's 1692. Therefore, you can only convict Anton Bastian of murder only if when he took part. One, he knew that Craig Johnson had a gun. Sorry for the wrong reference. So it's 1692, 16 to 19. So there, I'm obviously placing emphasis on when he took part. So in other words, he would have known of the presence of the gun at the commencement of the joint enterprise. The appellant's second point is a criticism of the judge that he failed to properly direct the jury on the scope of or the nature of the common intention, or the scope of the agreement. I think I've touched on this already, and this is what I accept. The judge could have done more in this respect. The judge could have given clearer directions concerning the extent and the nature of the common intent shared between the appellant and his co-defendants. But in my submission, the directions that were given were adequate. And as I said earlier, the jury would have understood the Crown's case, namely common plan to steal purses, to do so armed with a gun, and that it was for the jury to then determine the extent of that common intent based on all the evidence. The appellant's third point seeks to criticise the judge for failing to direct the jury at all as to the proper approach where one party fundamentally departs from the scope of a common agreement. Now, there's two answers in my submission to this. The first answer is that in my submission, the principles concerning overwhelming supervening act simply have no application in the present case. And I say that because if it is accepted that the appellant set out to rob with another individual who he knew was armed with a gun, and that due to an intervener that gun is fired and causes a death in the course of a robbery, this cannot, in my submission, amount to an overwhelming supervening act. Or put it another way, if the jury found that the appellant set out to commit an armed robbery, it is an obvious risk that someone is going to try to stop them, and therefore extremely unlikely that they would find that what Johnson did, namely shooting a gun with lethal effect, was radically different from the foreseen possibility. And we do say, and we set this out in paragraph 47 of our written case, that in deciding whether Johnson's actions in shooting the deceased were of such a different type, the use of Johnson of a gun is a significant factor, namely a gun with its propensity to cause death. And we've referred you to the case of Udin, which you've got at tab 22, which is 2935, which simply makes that point that the weapon used is relevant to considering whether there's been an overwhelming supervening act or someone has stepped outside an agreed plan or done something radically different, and that was foreseen as a possibility. And the Crown's second answer is that it's wrong to say that the judge simply failed to direct the jury on this. At 1691, the judge directs where two or more persons embark on a joint enterprise, each is criminally liable, and I'm reading, so it's lines 6 to 15, each is criminally liable for acts done in pursuance of the joint enterprise, including unusual circumstances arising from the execution of the joint enterprise. But if one of them goes beyond what was implicitly agreed as part of the joint enterprise, the other is not liable for the consequences of the unauthorised act. So again, although the judge could have said more, that direction is sufficient to safeguard against the jury, assuming that it followed automatically from the appellant's admitted involvement and knowledge of the gun, that he should be guilty. The appellant's fourth point is that having identified the specific issue of the presence of a weapon, it said that the judge failed to direct the jury as to any proper use that they should make of that fact. And again, we don't accept that criticism. I've taken the board to the direction that the jury received from the judge, that they would have understood he needed to have prior knowledge of the gun. That's 1691-27.
92, 1692.
I will keep on giving
16.
the wrong reference. 60, yes, thank you, my lady. 1692, 16, yes, to 19, thank you.
Sorry, 1692 line.
It's line 16 to 19.
Thank you.
And
So what do you say about that?
well, the jury would have understood from that direction that he can only be guilty of murder if, when he took part, he knew that Craig Johnson had a gun, that prior knowledge of the gun was fundamental.
Sorry, I think I got the reference wrong. It's page 1692.
1692.
Sorry,
it's my fault, my lord, for giving you twice the wrong reference.
Sorry,
1692, lines 16 to 19.
I've got it now, yes, it was my fault.
The jury would have also had in mind the case against Dorfevil. And as the board knows, so that he said in police interview, he admitted he was the driver of the vehicle, but he was unaware of any co-defendants had a gun. That evidence, 8/12/17 to 18. Obviously, contrast that with the statement given by the appellant superintendent Clark. And it was the Crown's case, which obviously must have been accepted by the jury, that the appellant knew at the time the vibe went down that Johnson had a gun. And the acquittal of...
Sorry, I didn't...
Well, the acquittal of Dorfeville of the murder and armed robbery and conviction of robbery underscores the significance of knowledge of a weapon.
Well, does it? Because the way the judge leaves it to the jury, if you start a little higher up, is that on the prosecution's case, they were all aware of the existence of a gun, and if you accept what they said about it, that's the answer, except in the case of Dorfeville.
Lady, yes. But the point being that it's the prior knowledge of a gun, which is the complaint, that it is being said that the judge doesn't explain to the jury that it's not simply knowledge of a gun, but it is prior knowledge of a gun. But I do accept that the point I make about Dorfeville perhaps doesn't take one that far. If I may move to the second issue, which is the failure to leave lesser alternative verdicts. The Crown takes no issue with the relevant legal framework, which the appellant has set out in their written case, paragraph 61 to 64. We also rely on, for convenience, the summary of the legal principles that are set out in Archbold, and we've given the board the relevant extract of Archbold at tab 26, which is 3028 and 3030.
3028, you said?
3028,
Yep.
that's para 4-532 from Archbold, and then 3030 is a later paragraph, paragraph 7-99, which deal with when lesser alternative verdicts ought to be left. And really the principles we draw from that is that not every alternative verdict must always be left to a jury. Again, that's uncontroversial. There is no requirement to leave an alternative verdict where such a verdict would not reflect the real issues in the case. And perhaps the point is put quite succinctly. It's Lord Roger in the Queen and Coots, which the board has at tab 7. It's para 85 of that judgment, which is 2682. And Lord Roger expresses the issue in this way. The question is whether it is a viable issue on a reasonable view of the evidence. And the Crown's position is that robbery and manslaughter, save insofar manslaughter related to Johnson's intention, were not viable lesser verdicts on a reasonable view of the evidence. Now, as the board will have seen from the summing up, manslaughter as an alternative to murder was left in the appellant's case, but on the basis that Johnson did not intend to kill the deceased, and that direction is at 1723, line 30, to 1724, line 3. I can deal first with the lesser verdict of robbery. The Crown's case, as the board will now obviously know very well, is that by his own admission in the two statements that he gave to the police, he admitted to taking part in a robbery with Johnson and had admitted that he knew Johnson had a gun. The appellant's case was not was that he was effectively not there. He ran alibi late in the day, but his case was not that he did not know Johnson had a gun. That's obviously to be contrasted with Dorfeville, who denied knowledge of the gun in the police interview. And the judge therefore directed the jury, in respect of Dorfeville, that if they were not sure he knew about the gun, he could be found guilty of robbery rather than armed robbery. That direction is at 1725-31. He did not give the same direction in respect to the appellant. And there's a discussion with Mr. Reckley on behalf of the appellant that the board can see starting at 1718-28. And it appears the distinction, obviously, between Dorfevil and the appellant is that there was evidence in Dorfevil's case, namely his own evidence. Whereas in the appellant's case, the judge, looking at the summing up, appears to have formed the view that the statement that was given to Superintendent Clark effectively admitted all the elements that were necessary of an armed robbery charge.
The Dorfeville direction was at 1691.
Let me check my reference before I confirm that. I've got it. It's in two places because there's a question raised by the foreman. So I gave you a reference of 1725-31, which is where the judge saying, if you find that Dorfevil did not know of a gun, then he will not know of the murder taking place, if that helps, and therefore he will only be guilty of robbery. There is an earlier, and I think
there's an earlier one at 1691.
That is an earlier reference as well.
Thank you.
So, in my submission, the judge is essentially saying that there is only one reading of that statement. That was the finding of the Court of Appeal, as I started in my submissions making the point and took you to the relevant paragraph of the Court of Appeal's judgment.
So you'd accept that the judge effectively took that issue away from the jury. She directed them that these were admissions, A, of participation, B, of knowledge from the outset that Johnson had a gun.
No, I don't, no, my lady, I don't accept that. I accept that the judge, when it came to what verdicts to leave, didn't leave robbery.
But where does sorry, I spoke over.
No. But the judge, obviously, on the armed robbery, leaves the issue open to the jury as to whether or not they accept what Superintendent Clark said, because the appellant says, well, I didn't say that. But if
she puts it to them as an issue of credibility, either he said it or he didn't, and you'll have to decide whether you believe Clark or whether you believe Bastian. But where does she say to the jury, it's a matter for you to decide whether this is an admission, A, of participation in a joint plan to snatch purses, and perhaps more significantly, B, knowledge from the outset that he was going along with somebody who was armed with a gun.
I think we go back to that passage at 16, as an example, 1692, where the judge is saying you have to find that the appellant knew that Johnson had a gun in advance. So that's an issue for the jury to determine.
But so are you accepting, or perhaps it doesn't matter, that the judge never said to the jury, it's a matter for you to decide what inferences to draw from the statement that Bastian made to Clark, if you accept that that was the statement he made?
I would accept that the judge doesn't, in those terms, put it in that way, my lady. But I would say that when one reads the summing up as a whole, the jury would have understood that in order to convict the appellant, they had to look at the words that were used by the appellant, if they accepted that that's what he said to Superintendent Clark, and draw reasonable inferences as to what those words mean. I mean, the jury would have understood that, and that is, in my submission, enough. On manslaughter as an alternative to murder, in our submission, when one looks at the questions that were asked by the jury, the judge's answers and the related exchanges with defence counsel, it was not thought that manslaughter would reflect the real issues in the case. And those relevant exchanges start at 1723, line 10. And what is clear from those exchanges is that the jury's concern was with the lack of an intent to kill on the part of Johnson. And at 1726, lines 23 to 27, you see the judge remarking having addressed those questions from the jury doesn't have any difficulty with joint responsibility or being concerned together. Their difficulty is whether the ingredients for murder are there or whether intention is lacking. So when one goes back to the principles where there's no requirement to leave an alternative verdict where it would not reflect the real issues in the case, I say that an alternative verdict of manslaughter would not have reflected the real issues in this case, largely for similar reasons to those I make in respect to the robbery and armed robbery.
Because the judge had thought that there was only one reading of the statement.
That the presence and use of a gun evinced the necessary intention to kill. My lords, my lady, if I can move then to issue 3, which is separate consideration of the cases and the evidence as against the 4 defendants. If I can start by just giving the board the references to the directions and the cautions that were given to the jury to the effect that they must consider each count separately and the case for and against each defendant on each count separately. There's 4 specific passages I just invite the board to note. The first is right at the beginning of the summation, 1621, line 29 to 1622, line 15. The judge says, first and foremost, this is a joint trial involving 5 defendants, 3 counts. That is simply done for convenience, otherwise we'd have 5 trials. You will be doing a grave injustice to all of the defendants if you simply group them together and say that they were all guilty or they were all not guilty. You must not do that. You must consider each count separately and the case against each defendant on each count separately. The evidence is different and therefore your verdict needs not be the same. So that's right at the start of the summing up. There's another caution given at 1673, lines 5 to 28. Particularly, I emphasise the latter part of that section where the judge says, again, I remind you to treat each defendant separately, do not lump them together. As you retire to the jury room to the appropriate time, I ask you to consider the case against each and for each defendant on each count separately. You may end up later that I direct you, but none of them are guilty of any offence. Some might be guilty of armed robbery, some of or more just robbery. And then when addressing joint enterprise, 1688, line 24 to 1689, line 19. Again, the last couple of lines of that section, your approach to the case should therefore be as follows. If looking at the case of any defendant, and I ask you to look at them separately, and the judge then goes on. And then bookending the summing up, so at the beginning you have the warning, and then right at the end you have a similar warning. Conclusion of the summing up, it's 1716, line 12 to 1717, line 4. Ending that top of 1717, again, as I've done throughout my summation, you must consider each count separately, the case against each defendant separately on each count. The evidence is different, therefore your verdicts need not be the same. So those directions in my submission that started and finished with an appropriate warning had cautions in between. That would have left the jury in no doubt that they had to approach the cases and the evidence of each defendant separately. As to the 5 specific complaints that the appellant makes, and we do deal with these in a written case, so I'll take them briefly. So first, the appellant quotes the conclusion of the judge's directions, where the judge states, if you find that all the ingredients have been satisfied, then the defendants will all be guilty of armed robbery. And the appellant criticises that.
Sorry,
so
where are you now? Sorry.
1688, line 23 to 23 is the relevant passage where the judge says, if you find that all the ingredients have been satisfied, then the defendants will all be guilty of armed robbery. And the criticism there is that that direction doesn't expressly state that all of the ingredients had to be satisfied in respect of each defendant. In my submission, that criticism is unfounded. The jury would have plainly understood from the judge's directions that they had to find all of the ingredients for armed robbery and murder to have been satisfied in respect
Sorry,
of
I can't find the passage in 1688.
Sorry, my lord. Let me... Six, 1688, line 3.
23.
Yes, it's the passage is starts at line 3 and then it's right down. Thank you. It's right down the bottom, 21 to 23, where the judge concludes by saying, "So, looking at it, if you find that
Yes,
all of
got
the
it.
ingredients have been satisfied."
Thank you.
So I simply say that can't be read in isolation or can't be read as the appellant contends. Given the other directions that have been given, the jury would have plainly understood that all of the ingredients for armed robbery and murder would have had to be satisfied in respect of each defendant. The second and third complaints I will take together. They concern the judge's direction to the jury that if they returned a verdict of manslaughter against Johnson, they must also return verdict of manslaughter against the appellant and Williams. So the appellant effectively says that the jury might have been left thinking that their verdict on murder would apply to Johnson, the appellant, and Williams without distinction. Again, I submit that in light of the directions that have been given to consider each case separately, that criticism is again unfounded, particularly where I have in mind the direction that it would be doing a grave injustice to the defendants if they did not consider each count against each defendant separately. The fourth complaint suggests that because each defendant relied on alibi and each contended that the mixed confessions were untrue or obtained by police brutality, it created a perception of one defence common to each that the jury might collectively reject. Again, and I apologise for repeating the same point, I say that complaint is unfounded if one reads the summing up as a whole, and particularly the directions and cautions about considering each case separately, such that the jury would have been in no doubt as to the issues in each of the defendants' cases that they had to consider. And then the final criticism is made that the judge did not direct the jury that they needed to determine whether the oral statement to Superintendent Clark suggested prior knowledge of the gun, but I've dealt with that. The fourth issue is the proviso, and the board has heard effectively what I have to say about the proviso already. We've set it out at paragraphs 60 to 61 of our written case, which is page 2452. In respect of issues 1 and 3, if the board was to conclude that there was a material irregularity, in my submission, no injustice can have resulted from such deficiency, as any jury properly directed would inevitably convict the appellant. The position, though, I think I'm right in saying it is different in respect of issue 2. Because if the board was to find that the judge wrongly omitted to direct the jury on a viable alternative verdict, in those circumstances, that would have to be regarded as a material misdirection. And again, I have in mind what was said by Lord Roger in the Cootes case that I referred you to on a different point earlier. It's paragraph 91, 2684.
When you say issue 2, you're referring
So
to...
this is the lesser verdict point. And the short point, to cut to the chase, is I don't think it can properly be said that the proviso could be applied if the board was to find that the judge ought to have left lesser verdicts of robbery or manslaughter. And what Lord Roger says at paragraph 91, which is 2684, says, in my view, therefore, in a case where the judge has wrongly omitted to direct the jury on a viable alternative verdict, the failure to give the direction must be regarded as a material misdirection. In Bullard, the Privy Council considered that failure to give the appropriate direction on manslaughter in the case of murder would always be irremediable. In the absence of a detailed argument on that particular point, it is enough to say that a failure to give the necessary direction must usually make the verdict unsafe, since the appeal court will have no sufficient basis for concluding that a reasonable jury would inevitably have convicted the appellant of murder if they had been given the appropriate direction. And a similar point is made, I think it's Lord Hutton, yes, paragraph 61, which is 2674. He says, I consider that the House should follow the reasoning in the second line of cases and hold that, save in exceptional circumstances, an appellate court should quash a conviction, whether for murder or for a lesser offence, as constituting a serious miscarriage of justice where the judge has erred in failing to leave a lesser alternative verdict obviously raised by the evidence. So obviously our primary case is the case you've heard on issue 2. We say it doesn't arise, but if the board is not with me and consider that the judge ought to have left manslaughter or robbery, I don't say this is such an exceptional case, and the proviso would not apply in my submission. So that's just to make clear, because that's not, I don't address that in our written case.
Thank you.
And I think there was a point raised at the end of my then friend's oral submissions that I should probably just deal with about a Lucas direction. So the submission, I think, really allied to the point he makes about alibi with the need for a Lucas direction. So just by way of the facts, the appellant appeared before magistrates in August 2013. So he was told then that if he wished to raise an alibi, he would need to serve an alibi notice within 21 days. Trial started 21st of September 2015. He didn't raise an alibi until he was questioned by the jury, as the board knows. You can see the relevant passage, just for your notes, is 1474. So the foreman of the jury asks a question, and in answer to the question he says, so I was with my girlfriend. So unsurprisingly, the Crown's case was that alibi was a recent fabrication. Directions on alibi were given by the judge at 1703 and 1704. Namely, that an adverse inference could be drawn where alibi notice requirement not complied with on a timely basis or at all. Judge told the jury that a false alibi could be given to bolster a true defence. And as to this point about a Lucas direction, so that if the jury accepted what was said to Superintendent Clark and Corporal Seymour, then it follows that obviously the alibi was rejected. The issue in the case was not one of credibility, but what could be reasonably inferred really from those two statements made to the police. So if the board was to conclude that a specific Lucas direction ought to have been given, then that misdirection is not sufficient to render the conviction unsafe on the facts of this case, given the evidence that was before the jury. And there's the case of Leslie that the board has, it's tab 15, 2819, and the judgment of Lord Justice Henry at 2830, which simply makes the point, the uncontroversial point, that failing to give a Lucas direction is not necessarily fatal. Everything turns in the circumstances of the case and the evidence in the case. And that leaves just the question of disposal. My submission, if the board was minded to quash the convictions, then the Crown would be seeking a retrial, but in the normal way, we would ask that this be remitted to the Court of Appeal for the Court of Appeal to consider submissions on disposal.
We say the statements are the only evidence. Wasn't there evidence about him taking them to where the bags were said to be disposed of?
Yes, and I'm probably wrongly grouping that together as part and parcel of Corporal Seymour's statement, but my Lord is right. There's Superintendent Clark's statement, Corporal Seymour's statement, and then the fact that he took two police officers on the Crown's case to where the bag that he described was found. I finished ahead of my allotted time, but unless there's any further questions.
I don't think so. Thank you very much. We're very grateful. Mr. Brew.
My Lords, my Lady, just a few points in response to matters that have arisen. So far as Rodney Johnson is concerned, you were taken by my learned friend to that judgment. It's the Court of Appeal Bahamas post-Jogi, looking at that relationship between that judgment and Farquharson and the principles in each. In that case, it's important to note that what the jury were actually directed upon was the Farquhar-Harson basis, the conditional intent. So you had to find the intention of the secondary party, even if it's conditional, i.e. only if necessary do this, but that has to be within the scope of the intentions of that secondary party. And you see that at paragraph 98 on page 2642 in particular, but there are a number of paragraphs of that judgment which indicate that point.
But it was on the Farquharson, it proceeded on the Farquharson.
Yes, the directions in that case made it clear to the jury before you convict the secondary party, you must conclude that they have the intention that the lethal force be used if necessary. That obviously differentiates that case heavily from the directions that the learned judge gave in this case, which don't begin to engage with that topic. On the question of knowledge of the firearm, prior or otherwise, my learned friend accepted that a starting point for the Crown must be knowledge of the gun, but of course knowledge is not sufficient on an appropriate, on a correct direction as in law. The question is whether in the circumstances the inference from knowledge is to be taken in all of the circumstances to infer intention to use a weapon, for example, in a particular way, or to have a weapon used as part of an offence. And my lady took me earlier to, or reminded me earlier, of the irresistible inference that might sometimes arise from knowledge of a weapon in certain circumstances. I mentioned a passage in Jogi which dealt with the relative strength or otherwise that might apply in all the circumstances. That's paragraph 26, page 2702. And what we submit is important is what is the nature of the enterprise itself. The starting point is very different in the cases where the enterprise is to cause harm. If you embark together to attack someone, to cause them injury, then the knowledge that each of you are going to do so with certain weapons may well go to significant weight in terms of inference of intent. But the starting point in this case is that offence A is robbery, which is committed in the act by grabbing handbags and running away. So whether or not knowledge of a weapon that another person carried which commits offence B is the particular category where one doesn't have a common enterprise starting point of committing harm to the person or serious harm to the person in terms of injury. And obviously one has to cause a level of injury before you become involved in a lethality of action. On the question of point, my Lord Burrows referred to muddled, and my learned friend accepted that there may be, well, he said, except it could be clearer in the directions. But can I just invite your attention back to for one moment to one passage in the summing up, which is on page 1692, which my learned friend has addressed you on in aspects. Essentially, the respondent's case, I understand to be, irrespective of directions about foresight or realisation being enough, that had to be read in context that murder required an intent to kill on the part of the principal, and therefore the misdirection is saved, essentially, by the jury joining the dots, and without any written direction, and with the benefit of being lay people, they are to understand what the judge meant differently to what she said. But what you see on the page itself is rather even more confirmatory of the appellant's case than that. On page 1692, lines 19 to 20, for example, and this is not the only place, there could be three bases upon which to convict. Either a common intention to kill, or, and I draw attention to the word or, realised, or foresaw, or had knowledge. So the idea that the jury should join the dots and read the directions as a whole and understand them in their deliberations as meaning that it all required an intention to kill on the part of Mr. Bastian doesn't survive the disjunctive that is clearly part of the directions it receives on foresight and foreseeability. I've already made a point about joint attacks with intentions to inflict harm being different to other offence A enterprises. In the case of Udin, which my learned friend made reference to, which is your page 2935, there is reference to that specifically because both of the individuals, secondary party and principal, had agreed to inflict GBH, or really serious harm. And on that basis, the question was whether the entirely different type of weapon used by one was a supervening event or not. So the references in the record are page 2934, letters F to H, 2953, letters B to D, the Court of Appeal decision in which the type of weapon became relevant when you were talking about an enterprise in which everyone had agreed to cause injury. But the question was whether a particular type of weapon might be outside of the scope of that agreement to injure. And that was why it was of particular interest in that case, what the type of weapon was or its nature. On to the point of timing of the knowledge of the gun, with respect, we submit there is no answer to the point that my Lady Simler has raised, which is that the judge, in effect, in denying the jury the alternative of robbery, denies them the opportunity to consider the timing as to whether or not, if the knowledge of the firearm is subsequent to the actual robbery or the agreement to rob, then the guilt would be of robbery as opposed to of armed robbery, because subsequent knowledge wouldn't have any inferential potential whatsoever in relation to any intent that had to be considered about that. So we do submit that that was a factual issue wrongly withdrawn from the jury, which is evident in the decision not to leave the alternative in Mr. Bastian's case. On the question of manslaughter, and this is dealing with alternative verdicts, as the court knows, my learned friend's address to you is that manslaughter simply wouldn't have reflected any issues. It could not have been an obvious alternative. That is in keeping with, in our respectful submission, omitting the steps of decision-making and finding a fact that a jury would need to undergo to understand and analyse what is the common intention and what is the specific intention of the secondary party. Because as soon as one analyses it from that perspective, it is clear how much is absent from this summing up. The jury were not asked to consider whether the common agreement extended to a particular use of the gun, to a particular harm committed by the gun, or to the use of the gun, in fact, at its far end in with lethal intent. It is plainly possible that a jury might consider, in all the circumstances, that the bag snatcher who has robbed a lady of her bag and run away without any weapon or threat or any behaviour of their own to cause harm or threaten harm may well not have shared an intention that somebody be shot in the neck in a lethal manner thereafter. The jury might, if adverse to the appellant, have decided, as a matter of fact, you shared some intent. If you knew about the gun, it must have, as a foundation, have found that in order to go further. But having done that wouldn't be sufficient. It would have to then apply that knowledge to say, in all the circumstances, do we infer you must have intended, we are sure that you intended, Mr. Bastian, that there be harm caused, or serious harm caused, or lethal harm caused. And it would have had to go through those steps to decide what it inferred from all the circumstances. That is not a matter, with respect, that counsel representing the prosecution, or even the judge summing up, can substitute when inferences are clearly matters for a jury, sometimes of difficulty, to take from primary facts that juries find to be proved, and what they take to be the meaning of those facts or words used, for example. So there was no exclusion of manslaughter as an option if the jury reached various different inferences of intent from the primary facts that it plainly had. As to the application of the proviso, we submit it is not simply a material irregularity that the jury are not informed of the correct test for legal liability to apply to a murder conviction. or for that matter, a shared intention to commit armed robbery. In terms of section 13 of the Penal Code, it results in an unsafe or unsatisfactory conviction. It is certainly an unfair trial to have a case put on a basis that isn't cross-examined and nor upon which the jury are asked to consider. And it involves misdirections of law on the fundamental ingredients of the offence as they pertain to a secondary liability. These are plainly not matters upon which the misdirection being found in any of those respects, a court applies a proviso and says it's inevitable that a jury must have convicted.
You say that there was no cross-examination in relation to the issue of intent because the issue of intent was never clearly identified.
Indeed, but my lord, it even goes further. If one looks at the cross-examination, I appreciate we haven't spent any great time on it, but it doesn't go as far as to say, and you must have realised that it doesn't even cross-examine on the basis of the mistake as to the legal test to say, well, that means that you realised that he would do this, didn't you? If necessary, if somebody was intervening, you meant that he should do this, didn't you? Or you foresaw it, rather. So that detail of cross-examination in terms of putting a case simply isn't there, even on the directions given, but a fortiori on what should have been the consideration for the jury. So we do respectfully depart from learned friend's submission that this is anywhere near a case for the proviso, and the inevitability of conviction that is the test that applies. And we do, of course, agree on the legal test. I think the court has those, we'll know them well in any event, but has those in our written cases in the bundle. And the last point of reply, if I may, is on the question of the Lucas direction and the alibi notice. We do, by contradistinction, note the length of cross-examination on that topic. But our point is a simple one, that if the jury were to decide that the alibi was not true, whether from an adverse inference drawn properly upon an absence of a notice or simply upon a rejection of the alibi as true, it was given no assistance with what it should or should not make of a conclusion, inevitably, if it has come to that conclusion, that it has been lied to about whether he was there. And the reason, the rationale for the Lucas direction, as applied to alibi notices as well in the Leslie case, is precisely because a jury might, in the common way that might occur, regard someone who's lied as guilty of the offence. That simply follows from the fact that we find that they've not told the truth about the alibi. It ought to have been given some assistance that that's not the case. And it was given there are some passages, I think, which hint at that in a general way, but it is not told. One of the reasons that you shouldn't convict of murder, for example, is that it might be that he hasn't told the truth if he's guilty of robbery. And therefore you should not rely upon that as proof of the mens rea or the mental state or the joint enterprise for murder or indeed for armed robbery. That is the principle that Bullen and Leslie both speak to, and Bullen in particular, because it's a case concerned with murder and manslaughter and concerned with whether or not the jury needs some assistance about what sort of adverse approach it might take to a lie told as to whether it does prove the mens rea of the more serious offence. It's classed essentially within the term innocent reasons. One often not innocent in that sense, but that's the more common element of the reasons that are suggested. But it is suggested to be one of those innocent reasons, and that terminology applies even inappositely. And of course, the other point here is that this was an extremely weak case. It relies on inferences from these two short statements. If the jury find they were not the result of oppression, if they find that they're accurate in their transcription, this was the state of the case. And so one has to consider, where did the jury go to try and fill in part of its deliberations about Mr. Bastian? It should not have gone to the material it was told was irrelevant, and one has to accept that the jury has been told that it is not to go there. But the inherent weakness of it does call into question the failure to give the jury any guidance on the question of what it was to do about the alibi, were it to conclude that the alibi was not a truthful defence. My lords, that was what I had by way of reply. And if there's anything I can assist you with, as we have the benefit of a few moments, but I hope we've covered what you need.
Thank you, Mr. Brewer. We're very grateful to you and to Mr. Poole, for your submissions, but also very grateful to those sitting alongside you, behind you, for the preparation of the case. And we will take time to consider our decision in the matter and to consider the advice we will, in due course, humbly tender to His Majesty. Very grateful to you all. Thank you very much.